Okay, good evening, everyone. Welcome again to another episode of Basic Transfer Pricing Philippines. And tonight we will continue with our discussions on intangibles. We have discussed intangibles the first time last week, last Monday in our live streaming, and today we will continue. This is the next topic, the preceding that in documentation, which is chapter 5 of this guideline. And tonight, this is part of the chapter 6 on intangibles. But I would like to say thank you sa ating mga subscribers po. Umabot na tayo ng 249 subscribers dito sa Basic Transfer Pricing. Ilan yung nanonood sa atin?
Viewers ko na 8 viewers.
Okay. Shout out.
Wala pa akong nag-comment.
Okay, so okay. Okay, so intangibles are very important because they are value drivers for business. So a lot of businesses, especially multinationals, are investing so much in intangibles. Why? Because intangibles, although they have no physical attributes, but still they are developed through times, and they help a lot in the business. So we learn how or what are some of the intangibles like patent, trademarks, trade names. So let's continue with our discussions on intangibles. And in fact, intangibles are very much issues in transfer pricing nowadays. So let's discuss the market-specific characteristics. Specific characteristics of a given market may affect the arm's length conditions of transactions in the market. For example, the high purchasing power of households in a particular market may affect the prices paid for certain luxury consumer goods. Similarly, low prevailing labor cost, proximity to markets, favorable weather conditions, unlike many, may affect the prices paid for specific goods and services in a particular market. Such market-specific characteristics are not capable, however, of being owned or controlled and are therefore not intangibles within the meaning of Section A.1. If the specific market characteristics cannot be owned and controlled, then they are not included as intangible. It should be taken into account in a transfer pricing analysis through the required comparability analysis. See Section D.6 of Chapter 1 for guidance regarding the transfer pricing treatment of market-specific characteristics. Ownership of intangibles and transactions involving the development, enhancement, maintenance, protection, and exploitation of intangibles. So, who is the owner of intangibles, and what are the transactions that will involve intangibles, especially in the development? In development, we mean the one who developed the intangibles through research and development. It can be group effort, and it will be determined the contributions of the group in the development of intangibles. Also, enhancement, there is already an existing intangible, how it is being enhanced or improved, and then the maintenance, the protection, who is the owner, the legal owner, registered, so that it can have the protection of the law, and the exploitation of intangibles, who uses the intangibles for their benefits. So the intangibles are exploited, they become valuable because they are exploited and form part of the product. So in transfer pricing cases involving intangibles, the determination of the entity or entities within an M&A group which are ultimately entitled to share in the returns derived by the group from exploiting intangibles is crucial. Our later issue is which entity or entities within the group should ultimately bear the cost, investments, and other burdens associated with the development, enhancement, maintenance, protection, and exploitation of intangibles. Although the legal owner of an intangible may receive the proceeds from the exploitation of the intangible, other members of the legal owners M&A group may have performed functions, used assets, or assumed risk that are expected to contribute to the value of the intangible. Members of the M&A group performing such functions, using such assets, and assuming such risks must be compensated for their contributions under the arm's length principle. This section B confirms that the ultimate allocation of the returns derived by the M&E group from the exploitation of intangibles and the ultimate allocation of costs and other burdens related to intangibles among members of the M&E group is accomplished by compensating members of the M&E group for functions performed, assets used, and risks assumed in the development, enhancement, maintenance, protection, and exploitations of intangible according to the principles described in Chapter 1 to 3. No? The acronym for this development, enhancement, maintenance, protection, and exploitation is DIMP. So this will determine who is the owner of the intangibles. Hari,
Well,
nilagyan mo na ba ng title yan?
ako nga may mga title na.
Tonight, the title is Discussion on Intangibles. Anong nilagay mong title?
Intangibles po.
Sige. Sige. Applying the provisions of Chapter 1 to 3 to address the questions can be highly challenging for a number of reasons. Depending on the facts of any given case involving intangibles, the following factors, among others, can create challenges. Number one, a lack of comparability between the intangible-related transactions undertaken between associated enterprises and those transactions that can be identified between independent enterprises. Two, a lack of comparability between the intangibles in question. Three, the ownership and or use of different intangibles by different associated enterprises within the M&A group. Number four, the difficulty of isolating the impact of any particular intangible on the M&A group's income. Number five, the fact that various members of an M&A group may perform activities relating to the development, enhancement, maintenance, protection, and exploitation of an intangible, often in a way and with a level of integration that is not observed between independent enterprises. The fact that contributions of various members of the M&A group to intangible value may take place in years different than the years in which any associated returns are realized. And seven, the fact that taxpayer structures may be based on contractual terms between associated enterprises that separate ownership, the assumption of risk, and or funding of investments in intangibles from performance of important functions, control over risk, and decisions related to investment in ways that are not observed in transactions between independent enterprises and that may contribute to base erosion and profit shifting. Notwithstanding these potential challenges, applying the arm's length principle and the provisions of chapters 1 and 3 within an established framework can, in most cases, yield an appropriate allocation of the returns derived by the M&A group from the exploitation of intangibles. The framework for analyzing transactions involving intangibles between associated enterprises requires taking the following steps consistent with the guidance for identifying the commercial or financial relations provided in section D.1 of chapter 1. Oh? So the intangibles are develop. And these are the steps, no, for analyzing the transactions involving intangibles between associated enterprises. So even if we know that intangibles are very important in business, in the study of intangibles, as it focused on transfer pricing, still study the application of the arm's length principle. No? So by arm's length principle, we mean that we compare the related party transactions with that of the independent transactions. No? So, so we have to identify the commercial or financial relations. Number one, identify the intangibles used or transferred in the transaction with specificity and the specific economically significant risk associated with the development, enhancement, maintenance, protection, and exploitation of the intangibles. Number two, identify the full contractual arrangements with special emphasis on determining the legal ownership of intangibles based on the terms and conditions of legal arrangements, including relevant registrations, license agreements, other relevant contracts, and other indicia of legal ownership, and the contractual rights and obligations, including contractual assumptions of risk in the relations between the associated enterprises. Number three, identify the parties performing functions, including specifically the important functions described in paragraph 6.56, using assets and managing risk related to developing, enhancing, maintaining, protecting, and exploiting the intangibles by means of the functional analysis, and in particular which party control any outsourced functions and control specific economically significant risk. Confirm the consistency between the terms of the relevant contractual arrangements and the conduct of the parties, and determine whether the party assuming economically significant risk under step 4(1) of paragraph 1.60 controls the risk and has the financial capacity to assume the risk relating to the development. Relating to the development, enhancement, maintenance, protection, and exploitation of intangibles. No? Acronym DIMP. No? So number 5, delineate the actual control transactions related to the development, enhancement, maintenance, protection, and exploitation of intangibles in light of the legal ownership of the intangibles, the other relevant contractual relations under relevant registrations and contracts, and the conduct of the parties, including the relevant contributions of functions, assets, and risks, taking into account the framework for analyzing and allocating risk under section D.1.2.1 of chapter 1. Number 6, where possible, determine arm's length prices for these transactions consistent with each party's contributions of functions performed, assets used, and risk assumed, unless the guidance in section D.2 of chapter 1 applies. Intangible ownership and contractual terms relating to intangibles. Legal rights and contractual arrangements form the starting point for any transfer pricing analysis of transactions involving intangibles. The terms of a transaction may be found in written contracts, public records, such as patent or trademark registrations, or in correspondence and or other communications among the parties. Contracts may describe the roles, responsibilities, and rights of associated enterprises with respect to intangibles. They may describe which entity or entities provide funding, undertake research and development, maintain and protect intangibles, and perform functions necessary to exploit the intangibles, such as manufacturing, marketing, and distribution. They may describe how receipts and expenses of the M&E associated with the intangibles are to be allocated, and may specify the form and amount of payment to all members of the group for their contributions. The prices and other conditions contained in such contracts may or may not be consistent with the arm's length principle. Where no written terms exist, or where the facts of the case including the conduct of the parties, differ from the written terms of any agreement between them or supplement these written terms, the actual transaction must be deduced from the facts as established, including the conduct of the parties. So it is therefore good practice for associated enterprises to document their decisions and intentions regarding the allocations of significant rights in intangibles. Documentation of such decisions and intentions, including written agreements, should generally be in place at or before the time that associated enterprises enter into transactions leading to the development, enhancement, maintenance, protection, or exploitation of intangibles. So that is for the intangibles. So this part explains the uh, suggestion of the OECD on how to document the financial and commercial transactions involving intangibles. So the decision and intentions regarding the allocation of significant rights in intangibles. So they should be documented. How this act of the management are to be documented. So there should be a written agreements, the decisions and the intentions generally placed at the time the associated enterprises enter into transactions. Because as we all know that the corporations are a juridical entity and all their decisions and all their acts are done through their board of directors. And the board of directors should make a board resolutions approving whatever act of the corporation. So that's part of the documentation that the company or the entity should show as proof during the transfer pricing audit. The right to use some types of intangibles may be protected under specific intellectual property laws and registration systems. In order that you can be protected, of course, you have to register with the Intellectual Property Office, and there is a fee for that in exchange of the protection that the agency will be provided to the owner of the intellectual property. Patents, trademarks, and copyrights are examples of such intangibles. Generally, the registered legal owner of such intangibles has the exclusive legal and commercial right to use the intangible as well as the right to prevent others from using or otherwise infringing the intangible. These rights may be granted for a specific geographic area and or for a specific period of time. So these rights, this protection during the registration with the IPO is limited by time and geographic area. By saying that it is limited by time, there is only a duration of the protection, especially if your protection lasts only for 3 years because you pay for the fee only for 3 years. After that, you're going to renew or you will never be protected. And when we say it is limited by geographic area, we mean that the protection is good only for a certain place. So in order for you that you will be protected internationally, then you have to pay a higher price or register your intangibles internationally. Ano mo na yung aircon. Sakit na sa mata. Okay. So there are also, ano mo yung isa. There are also intangibles that are not protectable under specific intellectual property registration systems, but that are protected against unauthorized appropriation or imitation under unfair competition legislation or other enforceable laws or by contract. Trade dress, trade secrets, and know-how may fall under this category of intangibles. No? So these are not protectable under intellectual property registration system. No? But unauthorized appropriation or imitations, no? They are protected. The extent and nature of the available protection under applicable law may vary from country to country, as may the conditions on which such protection is provided. Such differences can arise either from differences in substantive intellectual property law between countries or from practical differences in local enforcement of such laws. For example, the availability of legal protection for some intangibles may be subject to conditions such as continued commercial use of the intangible or timely renewal of registrations. This means that in some circumstances or jurisdictions, the degree of protection for an intangible may be extremely limited either legally or in practice. The legal owner will be considered to be the owner of the intangible for transfer pricing purposes, as against beneficial owner. The legal owner is the owner for transfer pricing purposes. If no legal owner of the intangible is identified under applicable law or governing contracts, then the member of the M&A group that, based on the facts and circumstances, controls decisions concerning the exploitation of the intangible and has the practical capacity to restrict others from using the intangible will be considered the legal owner of the intangible for transfer pricing purposes. Because even if they are not pinpointed actually that they are the owners, but since they are the one controlling and making use of that intangibles, then from their acts, it is manifested that they are the legal owner of the intangibles. In identifying the legal owner of intangibles, an intangible and any license relating to that intangible are considered to be different intangibles for transfer pricing purposes, each having a different owner. See paragraph 6.26. For example, Company A, the legal owner of a trademark, may provide an exclusive license to Company B to manufacture, market, and sell goods using the trademark. One intangible, the trademark, is legally owned by Company A. Another intangible, the license to use the trademark in connection with manufacturing, marketing, and distribution of trademark products, is legally owned by Company B. So depending on the facts and circumstances, marketing activities undertaken by Company B pursuant to its license may potentially affect the value of the underlying intangible legally owned by Company A, the value of Company B's license, or both. While determining legal ownership and contractual arrangement is an important first step in the analysis, these determinations are separate and distinct from the question of remuneration under the arm's length principle. For transfer pricing purposes, legal ownership of intangibles by itself does not confer any right ultimately to retain returns derived by the M&A group from exploiting the intangible, even though such returns may initially accrue to the legal owner as a result of its legal or contractual right to exploit the intangible. The return ultimately retained by or attributed to the legal owner depends upon the functions it performs, the assets it uses, and the risk it assumes, and upon the contributions made by other M&A group members to their functions performed, assets used, and risk assumed. For example, in the case of an internally developed intangible, if the legal owner performs no relevant functions, uses no relevant assets, and assumes no relevant risk, but acts solely as a title holding entity, the legal owner will not ultimately be entitled to any portion of the return derived by the M&A group from the exploitation of the intangible, other than arm's length compensation, if any, for holding title. So this is the guide of the OECD. So even if the legal owner or the registered owner is the registered owner of that intangible, if he has no participation for the development whatsoever of that intangible, but merely holding title for the intangible, then it cannot receive any benefits from the intangibles except compensation for holding title. Legal ownership and contractual relationships serve simply as reference point for identifying and analyzing control transactions relating to the intangible and for determining the appropriate remuneration to the members of a controlled group with respect to those transactions. Identification of legal ownership combined with the identification and compensation of relevant functions performed, assets used, and risk assumed by all contributing members provides the analytical framework for identifying arm's length prices and other conditions for transactions involving intangibles. As with any other type of transaction, the analysis must take into account all of the relevant facts and circumstances present in a particular case, and price determinations must reflect the realistic alternatives of the relevant group members. The principles of this paragraph are illustrated by examples 1 to 6 in the annex to chapter 6. No? So just like what we did with chapter 5, after we discussed the content of the chapter 5 on documentation, we again go to the annexes. No? So that hand in hand we also discuss the annexes. No? So after we have this chapter 6, we will also go to the annexes for intangibles, no? So that we can discuss also the examples. No? So because the actual outcomes and manner in which risk associated with the development or acquisition of an intangible will play out over time are not known with certainty at the time members of the M&A group make decisions regarding intangibles, it is important to distinguish between A, anticipated or ex-ante remuneration, which refers to the future income expected to be derived by a member of the M&A group at the time of a transaction, and actual or ex-post remuneration. No? So ex-ante is the future income, while ex-post remuneration is the actual, which refers to the income actually earned by a member of the group through the exploitation of the intangible. So these are the things that we have to remember in intangibles: the ex post remuneration and also the ex ante remuneration. When we say ex ante remuneration, we refers to the future income, while when we say ex post remuneration, we refer to the actual payment or actual income of the entity. The terms of the compensation that must be paid to members of the M&A group that contribute to the development, enhancement, or DIMP. No? In short, DIMP means development, enhancement, maintenance, protection, and exploitation of intangibles. It's generally determined on an ex-ante basis. When we say ex-ante basis, we mean the future income. That is, it is determined at the time transactions are entered into and before risk associated with the intangible play out. The form of such compensation may be fixed or contingent. The actual ex post profit or loss of the business after compensating other members of the M&A group may differ from these anticipated profits, depending on how the risk associated with the intangible or the other relevant risk related to the transaction or arrangement actually play out. The accurately delineated transaction as determined under section D.1 of chapter 1 will determine which associated entity assumes such risk and accordingly will bear the consequences, cost, or additional returns when the risk materializes in a different manner to what was anticipated. See section B.2.4. An important question is how to determine the appropriate arm's length remuneration to members of a group for their functions, assets, and risks within the framework established by the taxpayers' contractual arrangements, the legal ownership of intangibles, and the conduct of the parties. Section B.2 discusses the application of the arm's length principle to situations involving intangibles. It focuses on the functions, assets, and risks related to the intangibles. Unless stated otherwise, references to arm's length returns and arm's length remuneration in Section B.2 refer to anticipated ex ante returns and remuneration. Functions, assets, and risks related to intangibles. As stated above, a determination that a particular group member is the legal owner of intangibles does not, in and of itself, necessarily imply that the legal owner is entitled to any income generated by the business after compensating other members of the M&A group for their contributions in the form of functions performed, assets used, and risk assumed. In identifying arm's length prices for transactions among associated enterprises, the contributions of members of the group related to the creation of intangible value should be considered and appropriately rewarded. The arm's length principle and the principles of chapters 1 to 3 require that all members of the group receive appropriate compensation for any functions they perform, assets they use, and risks they assume in connection with the development, enhancement, maintenance, protection, and exploitation of intangibles. It is therefore necessary to determine by means of a functional analysis which members perform and exercise control over development, enhancement, maintenance, protection, and exploitation functions, which members provide funding and other assets, and which members assume the various risks associated with the intangible. Of course, in each of these areas, this may or may not be the legal owner of the intangible. As noted in paragraph 6.133, it is also important in determining arm's length compensation for functions performed, assets used, and risk assumed to consider comparability factors that may contribute to the creation of value or the generation of returns derived by the M&A group from the exploitation of intangibles in determining prices for relevant transactions. The relative importance of contributions to the creation of intangible value by members of the group in the form of functions performed, assets used, and risk assumed will vary depending on the circumstances. For example, assume that a fully developed and currently exploitable intangible is purchased from a third party by a member of a group and exploited through manufacturing and distribution functions performed by other group members while being actively managed and controlled by the entity purchasing the intangible. It is assumed that this intangible would require no development, may require little or no maintenance or protection, and may have limited usefulness outside the area of exploitation intended at the time of the acquisition. Therefore, there would be no development risk associated with the intangible, although there are risks associated with acquiring and exploiting the intangible. The key functions performed by the purchaser are those necessary to select the most appropriate intangible on the market, to analyze its potential benefits if used by the M&A group, and the decision to take on the risk bearing opportunity through purchasing the intangible. Buksan mo nga yung mga computer doon.
Nakabukas na po ba?
Lahat?
Apo.
Yung sa akin.
Hindi po kami sa inyo.
Oh, tapos ito.
Ito ma'am. Bukas.
The key asset used is the funding required to purchase the intangible. If the purchaser has the capacity and actually performs all the key functions described, including control of the risk associated with acquiring and exploiting the intangible, it may be reasonable to conclude that after making arm's length payment for the manufacturing and distribution functions of other associated enterprises, the owner would be entitled to retain or have attributed to it any income or loss derived from the post-acquisition exploitation of the intangible. While the application of chapters 1 to 3 may be fairly straightforward in such a simple fact pattern, The analysis may be more difficult in situations in which intangibles are self-developed by a multinational group, especially when such intangibles are transferred between associated enterprises while still under development, or acquired or self-developed intangibles serve as platforms for further development, or other aspects such as marketing or manufacturing are particularly important to value creation. The generally applicable guidance below is particularly relevant for and is primarily concerned with these more difficult cases. Sinishare mo ba ito pagkatapos sa Facebook?
Ako, madam.
Okay. Sige. Performance and control of functions. So we're still discussing about the intangibles, and this time about the control of functions. Since we are dealing with the arm's length principle, and parties involved are related parties. Under the principles of chapters 1 and 3, each member of the M&A group should receive arm's length compensation for the functions it performs. In cases involving intangibles, this includes functions related to the development, enhancement, maintenance, protection, and exploitation of intangibles. The identity of the member or members of the group performing functions related to the development, enhancement, maintenance, protection, and exploitation of intangibles, therefore, is one of the key considerations in determining arm's length conditions for controlled transactions. The need to ensure that all members of the M&A group are appropriately compensated for the functions they perform, the assets they contribute, and the risk they assume implies that if the legal owner of intangibles is to be entitled ultimately to retain all of the returns derived from exploitation of the intangibles, it must perform all of the functions, contribute all assets used, and assume all risk related to the development, enhancement, maintenance, protection, and exploitation of the intangible. This does not imply, however, that the associated enterprises constituting an M&A group must structure their operations regarding the development, enhancement, maintenance, protection, or exploitation of intangibles in any particular way. It is not essential that the legal owner physically performs all of the functions related to the development, enhancement, maintenance, protection, and exploitation of an intangible through its own personnel in order to be entitled ultimately to retain or be attributed a portion of the return derived by the M&A group from exploitation of the intangibles. In transactions between independent enterprises, certain functions are sometimes outsourced to other entities. A member of an M&A group that is the legal owner of intangibles could similarly outsource functions related to the development, enhancement, maintenance, protection, or exploitation of intangibles to either independent enterprises or associated enterprises. So just like any other resources, intangibles can also be outsourced. And depending on the setup of the related parties, the protection, the DEMPE, in other words, development, enhancement, maintenance, protection, or intangibles, or exploitation of intangibles can be outsourced either to a related parties or to an independent parties. Walang shout out?
Wala pa pong nag-call.
Ilan yung ating viewers?
Yung viewers po na 8 viewers.
Okay. So where associated enterprises other than the legal owner perform relevant functions that are anticipated to contribute to the value of the intangibles, these should be compensated on an arm's length basis for the functions they perform under the principles set out in chapters 1 to 3. The determination of arm's length compensation for functional contributions should consider the availability of comparable uncontrolled transactions, the importance of the functions performed to the creation of intangible value, and the realistically available options of the parties. The specific considerations described in paragraphs 6.53 to 6.58 should also be taken into account. In outsourcing transactions between independent enterprises, it is usually the case that an entity performing functions on behalf of the legal owner of the intangible that relate to the development, enhancement, maintenance, protection, and exploitation of the intangible will operate under the control of such legal owner as discussed in paragraph 1.65. Because of the nature of the relationships between associated enterprises that are members of an M&A group, however, it may be the case that outsourced functions performed by associated enterprises will be controlled by an entity other than the legal owner of the intangibles. In such cases, the legal owner of the intangible should also compensate the entity performing control functions related to the development, enhancement, maintenance, protection, and exploitation of intangibles on an arm's length basis. In assessing what member of the M&A group in fact controls the performance of the relevant functions, principles apply analogous to those for determining control over risk in section D.1.2.1 of chapter 1. Assessing the capacity of a particular entity to exert control and the actual performance of such control functions will be an important part of the analysis. If the legal owner neither controls nor performs the functions related to the development, enhancement, maintenance, protection, or exploitation of the intangible, the legal owner would not be entitled to any ongoing benefit attributable to the outsourced functions. Depending on the facts, the arm's length compensation required to be provided by the legal owner to other associated enterprises performing or controlling functions related to the development, enhancement, maintenance, protection, or exploitation of intangibles may comprise any share of the total return derived from exploitation of the intangibles. A legal owner not performing any relevant function relating to the development, enhancement, maintenance, protection, or exploitation of the intangible will therefore not be entitled to any portion of such returns related to the performance or control of functions relating to the development, enhancement, maintenance, protection, or exploitation of the intangible. It is entitled to an arm's length compensation for any functions it actually performs, any assets it actually uses, and risks it actually assumes. See section B.2.2 to B.2.3. In determining the functions it actually performs, assets it actually uses, and the risks it actually assumes, the guidance in section D.1.2 of chapter 1 is especially relevant. The relative value of contributions to development, enhancement, maintenance, protection, and exploitation of intangibles varies depending on the particular facts of the case. The M&A group members making the more significant contributions in a particular case should receive relatively greater remuneration. For example, a company that merely funds research and development should have a lower anticipated return than if it both funds and controls research and development. Other things being equal, a still higher anticipated return should be provided if the entity funds, controls, and physically performs the research and development. See also the discussion of funding in section B.2.2. In considering the arm's length compensation for functional contributions of various members of the M&A group, certain important functions in any specific case will depend on the facts and circumstances. For self-developed intangibles, or for self-developed or acquired intangibles that serve as a platform for further development activities, these more important functions may include, among others, design and control of research and marketing programs, direction of and establishing priorities for creative undertakings, including determining the course of blue sky research, control over strategic decisions regarding intangible development programs, and management and control of budgets. For any intangible, for instance, for either self-developed or acquired intangibles, other important functions may also include important decisions regarding defense and protection of intangibles and ongoing quality control over functions performed by independent or associated enterprises that may have a material effect on the value of the intangible. Those important functions usually make a significant contribution to intangible value, and if those important functions are outsourced by the legal owner in transactions between associated enterprises, the performance of those functions should be compensated with an appropriate share of the returns derived by the M&A group from the exploitation of intangibles. Because it may be difficult to find comparable transactions involving the outsourcing of such important functions, it may be necessary to utilize transfer pricing methods not directly based on comparables, including transactional profit split methods and ex ante valuation techniques, to appropriately reward the performance of those important functions. Where the legal owner outsources most or all of such important functions to other group members, attribution to the legal owner of any material portion of the return derived from the exploitation of the intangibles after compensating other group members for their functions should be carefully considered, taking into account the functions it actually performs, the assets it actually uses, and the risk it actually assumes under the guidance in section D.1.2 of chapter 1. Examples 16 and 17 in the annex to chapter 6 illustrate the principles contained in this paragraph. So in this discussion, the important point here is the application of the FAR analysis or the functions, assets, and risks as it applies to the study of intangibles. And as I told you, I will also discuss along the way after finishing the chapter 6, we will go to annexes to chapter 6. So because the important functions described in paragraph 6.56 are often instrumental in managing the different functions performed, assets used, and risks assumed that are key to the successful development, enhancement, maintenance, protection, or exploitation of intangibles and are therefore essential to the creation of intangible value, it is necessary to carefully evaluate transactions between parties performing these important functions and other associated enterprises. In particular, the reliability of a one-sided transfer pricing method will be substantially reduced if the party or parties performing significant portions of the important functions are treated as the tested party or parties. See example 6. Use of assets. Group members that use assets in the development, enhancement, maintenance, protection, and exploitation of an intangible should receive appropriate compensation for doing so. Huh? So, if you contribute to the development, enhancement, maintenance of the intangibles, then under the arm's length principle, you should be, or that party should be properly compensated. Such assets may include, without limitation, intangibles used in research, development, or marketing. For instance, know-how, customer relationships, and others. Physical assets or funding. One member of an M&A group may fund some or all of the development, enhancement, maintenance, and protection of an intangible, while one or more other members perform all of the relevant functions. When assessing the appropriate anticipated return to funding in such circumstances, it should be recognized that in arm's length transactions, a party that provides funding but does not control the risk or perform other functions associated with a funded activity or asset generally does not receive anticipated returns equivalent to those received by an otherwise similarly situated investor who also performs and controls important functions and controls important risk associated with the funded activity. The nature and amount of compensation attributable to an entity that bears intangible related cost without more must be determined on the basis of all the relevant facts and should be consistent with similar funding arrangements among independent entities where such arrangement can be identified. See the guidance in section D.1.2.1.6 of chapter 1 and in particular example 3 in paragraphs 1.85 and 1.103 which illustrate a situation where the party providing funding does not control the financial risk associated with the funding. Funding and risk-taking are integrally related in the sense that funding often coincides with the taking of certain risk, the funding party contractually assuming the risk of loss of its funds. The nature and extent of the risk assumed, however, will vary depending on the economically relevant characteristics of the transaction. The risk will, for example, be lower when the party to which the funding is provided has a high credit worthiness, or when assets are fleets, or when the investment funded is low risk compared with the risk where the credit worthiness is lower, or the funding is unsecured, or the investment being funded is high risk. Moreover, the larger the amount of the funds provided, the larger the potential impact of the risk on the provider of the funding. Under the principles of section D.1.2 of chapter 1, the first step in a transfer pricing analysis in relation to risk is to identify the economically significant risk with specificity. When identifying risk in relation to an investment with specificity, it is important to distinguish between the financial risks that are linked to the funding provided for the investment and the operational risk that are linked to the operational activities for which the funding is used, such as, for example, the development risk when the funding is used for developing a new intangible. Where a party providing funding exercises control over the financial risk associated with the provision of funding without the assumption of including the control over any other specific risk, it could generally only expect a risk-adjusted return on its funding. So these are very clear. No? This portion discusses about the funding of the research and development and the share or the remuneration that the contributor to the funding will get as remuneration for its contribution in the development of intangibles. The contractual arrangement will generally determine the terms of the funding transaction. Excuse me. As clarified or supplemented by the economic characteristics of the transaction, as reflected in the conduct of the parties. The return that will generally be expected by the funder should equal an appropriate risk-adjusted return. Such return can be determined, for example, based on the cost of capital or the return of a realistic alternative investment with comparable economic characteristics. In determining an appropriate return for the funding activities, it is important to consider the financing options realistically available to the party receiving the funds. There may be a difference between the return expected by the funder on an ex ante basis and the actual return received on an ex post basis. No? So as we have learned in our previous discussion, ex post is the actual, while ex ante is the future income that is to be derived in the exploitation of intangibles. For example, when the funder provides a loan for a fixed amount at a fixed interest rate, the difference between the actual and expected returns will reflect the risk playing out that the borrower cannot make some or all of the payments due. The extent and form of the activities that will be necessary to exercise control over the financial risk attached to the provision of funding will depend on the riskiness of the investment for the funder, taking into account the amount of money at stake and the investment for which these funds are used. In accordance with the definition of control as reflected in paragraphs 1.65 and 1.66 of these guidelines, exercising control over a specific financial risk requires the capability to make the relevant decisions related to the risk-bearing opportunity. In this case, the provision of the funding, together with the actual performance of these decision-making functions. In addition, the party exercising control over the financial risk must perform the activities as indicated in paragraph 1.65 and 1.66 in relation to the day-to-day risk mitigation activities related to this risk when these are outsourced, unrelated to any preparatory work necessary to facilitate the decision making if it does not perform these activities itself. When funding is provided to a party for the development of an intangible, the relevant decisions relating to taking on, laying off, or declining a risk-bearing opportunity, and the decisions on whether and how to respond to the risk associated with the opportunity are the decisions related to the provisions of funding and the conditions of the transaction. Depending on the facts and circumstances, such decisions may depend on an assessment of the creditworthiness of the party receiving the funds and an assessment of how the risk related to the development project may impact the expectation in relation to the returns on funding provided or additional funding required. The conditions underlying the provisions of the funding may include the possibility to link funding decisions to key development decisions which will impact the funding return. For example, decisions may have to be made on whether to take the project to the next stage or to allow the investments in costly assets. The higher the development risk and the closer the financial risk is related to the development risk, the more the funder will need to have the capability to assess the progress of the development of the intangible and the consequences of this progress for achieving its expected funding return, and the more closely the funder may link the continued provision of funding to key operational developments that may impact its financial risk. The funder will need to have the capability to make the assessments regarding the continued provision of funding and will need to actually make such assessments, which will then need to be taken into account by the funder in actually making the relevant decisions on the provision of funding. Okay? So as we can see in the discussions of the OECD, it all boils down to the related parties' dealings with other related parties in terms of the development and use of intangibles. How this party or group are being compensated or remunerated on their participation. So that even if we are discussing about intangibles, but since our discussion is related to transfer pricing, then it will somewhat focus on the arm's length principle. No? So and when we say arm's length principle, we mean that we have to adapt what the independent parties are doing with that similar transactions in dealing with the intangibles as compared to the uh, dealings of related parties also with regards to certain intangibles. Assumption of risk. Particular types of risk that may have importance in a functional analysis relating to transactions involving intangibles include risk related to development of intangibles, including the risk that costly research and development or marketing activities will prove to be unsuccessful, and taking into account the timing of the investment. For example, whether the investment is made at an early stage, midway through the development process, or at a late stage will impact the level of the underlying investment risk. The risk of product obsolescence, including the possibility that the technological advances of competitors will adversely affect the value of the intangibles. 3. Infringement risk, including the risk that defense of intangible rights or defense against other persons' claims of infringement may prove to be time-consuming, costly, and/or unavailing. Product liability and similar risks related to products and services based on the intangibles, and exploitation risk, uncertainties in relation to the returns to be generated by the intangible. The existence and level of such risk will depend on the facts and circumstances of each individual case and the nature of the intangible in question. The identity of the member or members of the group assuming risk related to the development, enhancement, maintenance, protection, and exploitation of intangibles is an important consideration in determining prices for controlled transactions. The assumption of risk will determine which entity or entities will be responsible for the consequences if the risk materializes. The accurate delineation of the controlled transaction based on the guidance in section D.1 of chapter 1 may determine that the legal owner assumes risk or that instead other members of the group are assuming risk, and such members must be compensated for their contributions in that regard. In determining which member or members of the group assume risk related to intangibles, the principles of section D.1.2 of chapter 1 apply. In particular, steps 1 to 5 of the process to analyze risk in a controlled transaction as laid out in paragraph 1.60 should be followed in determining which party assumes risk related to the development, enhancement, maintenance, protection, and exploitation of intangibles. It is especially important to ensure that the group members asserting entitlement to returns from assuming risk actually bear responsibility for the actions that need to be taken and the cost that may be incurred if the relevant risk materializes. If costs are borne or actions are undertaken by an associated enterprise other than the associated enterprise assuming the risk as determined under the framework for analyzing risk reflected in paragraph 1.60 of these guidelines, then a transfer pricing adjustment should be made so that the costs are allocated to the party assuming the risk and the other associated enterprises is appropriately remunerated for any activities undertaken in connection with the materialization of the risk. Example 7 in the annex to chapter 6 illustrate this principle. Actual ex post returns. It is quite common that actual ex post profitability is different than anticipated ex ante profitability. This may result from risk materializing in a different way to what was anticipated through the occurrence of unforeseeable developments. For example, it may happen that a competitive product is removed from the market. A natural disaster takes place in a key market. A key asset malfunctions or foreseeable reasons, or that a breakthrough technological development by a competitor will have the effect of making products based on the intangible in question obsolete or less desirable. It may also happen that the financial projections on which calculations of ex ante returns and compensation arrangements are based properly took into account risk and the probability of reasonably foreseeable events occurring, and that the differences between actual and anticipated profitability reflects the playing out of those risks. Finally, it may happen that financial projections on which calculations of ex ante returns and compensation arrangements are based did not adequately take into account the risk of different outcomes occurring and therefore led to an overestimation or an underestimation of the anticipated profits. The question arises in such circumstances whether, and if so, how the profits or losses should be shared among members of an M&A group that have contributed to the development, enhancement, maintenance, protection, and exploitation of the intangible in question. Resolution of this question requires a careful analysis of which entity or entities in the M&A group in fact assume the economically significant risk as identified when delineating the actual transaction. See Section D.1 of Chapter 1. As this analytical framework indicates, the party actually assuming the economically significant risk may or may not be the associated enterprise contractually assuming this risk, such as the legal owner of the intangible, or may not be the funder of the investment. A party which is not allocated the risk that give rise to the deviation between the anticipated and actual outcomes under the principles of sections D.1.2, .1.4 to D.1.2.1.6 of Chapter 1 will not be entitled to the difference between actual and anticipated profits or required to bear losses that are caused by these differences if such risk materializes, unless these parties are performing the important functions reflected in paragraph 6.56 or contributing to the control over the economically significant risk as established in paragraph 1.105, and it is determined that arm's length remuneration of these functions would include a profit sharing element. In addition, consideration must be given to whether the ex ante remuneration paid to members of the M&A group for their functions performed, assets used, and risk assumed is in fact consistent with the arm's length principle. Care should be taken to ascertain, for example, whether the group in fact underestimated or overestimated anticipated profits, thereby giving rise to underpayments or overpayments, determined on an ex ante basis to some group members for their contributions. Transactions for which valuation is highly uncertain at the time of the transaction are particularly susceptible to such under or overestimations of value. This is further discussed in section D.4. B.2.5. Some implications from applying sections B.1 and B.2. If the legal owner of an intangible in substance performs and controls all of the functions, including the important functions described in paragraph 6.56, related to the development, enhancement, maintenance, protection, and exploitation of the intangible, provides all assets, including funding necessary to the development, enhancement, maintenance, protection, and exploitation of the intangibles, assumes all of the risk related to the development, enhancement, maintenance, protection, and exploitation of the intangibles. Then it will be entitled to all of the anticipated ex ante returns derived from the M&A group's exploitation of the intangible. So this discussion focused on who owns the income after the intangibles has been developed. To the extent that one or more members of the M&A group, other than the legal owner, performs functions, uses assets, or assumes risks related to the development, enhancement, maintenance, protection, and exploitation of the intangible, such associated enterprises must be compensated on an arm's length basis for their contributions. This compensation may, depending on the facts and circumstances, constitute all or a substantial part of the return anticipated to be derived from the exploitation of the intangible. The entitlement of any member of the M&A group to profit or loss relating to differences between actual ex post and a proper estimation of anticipated ex ante profitability will depend on which entity or entities in that M&A group in fact assumes the risk as identified when delineating the actual transactions, see section D.1 of chapter 1. It will also depend on the entity or entities which are performing the important functions as reflected in paragraph 6.56 or contributing to the control over the economically significant risk as established in paragraph 1.105, and for which it is determined that an arm's length remuneration of these functions would include a profit sharing element. Identifying and determining the prices and other conditions for the controlled transactions. Undertaking the analysis described in section D.1 of chapter 1, as supplemented by this chapter, should facilitate a clear assessment of legal ownership functions, assets, and risks associated with intangibles, and an accurate identification of the transactions whose prices and other conditions require determination. In general, the transactions identified by the M&E group in the relevant registrations and contracts are those whose prices and other conditions are to be determined under the arm's length principle. However, the analysis may reveal the transaction in addition to or different from the transactions described in the registration and contracts actually occurred. Consistently with section D.1 of chapter 1, the transactions and the true terms thereof to be analyzed are those determined to have occurred consistent with the actual conduct of the parties and other relevant facts. Arm's length prices and other conditions for transaction should be determined according to the guidance in Chapter 1 to 3, taking into account the contributions to anticipated intangible, value of functions performed, assets used, and risk assumed at the time such functions are performed, assets are used, or risks are assumed, as discussed in this section B of this chapter. Section D of this chapter provides supplemental guidance on transfer pricing methods and other matters applicable in determining arm's length prices and other conditions for transactions involving intangibles. Application of the foregoing principles in specific fact patterns. The principles set out in this section B must be applied in a variety of situations involving the development, enhancement, maintenance, protection, and exploitation of intangibles. A key consideration in each case is that associated enterprises that contribute to the development, enhancement, maintenance, protection, or exploitation of intangibles legally owned by another member of the group must receive arm's length compensation for the functions they perform, the risk they assume, and the assets they use. In evaluating whether associated enterprises that perform functions or assume risk related to the development, enhancement, maintenance, protection, and exploitation of intangibles have been compensated on an arm's length basis, it is necessary to consider the level and nature of the activity undertaken and the amount and form of compensation paid. In assessing whether the compensation provided in the control transaction is consistent with the arm's length principle, reference should be made to the level and nature of activity of comparable uncontrolled entities performing similar functions. The compensation received by comparable uncontrolled entities performing similar functions and the anticipated creation of intangible value by comparable uncontrolled entities performing similar functions. This section describes the application of these principles in commonly occurring fact patterns. Okay. So before we proceed, let's have a 5 minutes break. Ilan na yung ating before we proceed, let's have a 5 minutes break. Ilan na yung ating Okay, so let's continue with our discussion on intangibles. So if you try to think about it, the discussion focused mainly on the development, enhancement, protection, maintenance, and exploitation of intangibles. Oh, okay. So development and enhancement of marketing intangibles. Oh, a common situation where these principles must be applied arises when an enterprise associated with legal owner of trademarks perform marketing or sales functions that benefit the legal owner of the trademark. For example, through a marketing arrangement or through a distribution marketing arrangement. In such cases, it is necessary to determine how the marketer or distributor should be compensated for its activities. One important issue is whether the marketer distributor should be compensated only for providing promotion and distribution services, or whether the marketer distributor should also be compensated for enhancing the value of the trademarks and other marketing intangibles by virtue of its functions performed, assets used, and risk assumed. The analysis of this issue requires an assessment of the obligations and rights implied by the legal registrations and agreements between the parties, the functions performed, the assets used, and the risk assumed by the parties, the intangible value anticipated to be created through the marketer distributor activities, and the compensation provided for the functions performed by the marketer distributor, taking account of the assets used and risk assumed. One relatively clear case is where a distributor acts merely as an agent, being reimbursed for its promotional expenditures and being directed uncontrolled in its activities by the owner of the trademarks and other marketing intangibles. In that case, the distributor ordinarily would be entitled to compensation appropriate to its activity, to its agency activities alone. It does not assume the risks associated with the further development of the trademark and other marketing intangibles, and would therefore not be entitled to additional remuneration in that regard. So in this case, no further remuneration is expected by the entity who does not assume the risk associated with the further development of the trademark. When the distributor actually bears the cost of its marketing activities, for example, when there is no arrangement for the legal owner to reimburse the expenditures, the analysis should focus on the extent to which the distributor is able to share in the potential benefits deriving from its functions performed, assets used, and risks assumed currently or in the future. In general, in arms length transactions, the ability of a party that is not the legal owner of trademarks and other marketing intangibles to obtain the benefits of marketing activities that enhance the value of those intangibles will depend principally on the substance of the rights of that party. For example, a distributor may have the ability to obtain benefits from its functions performed, assets used, and risk assumed in developing the value of a trademark and other marketing intangibles from its turnover and market share when it has a long-term contract providing for sole distribution rights for the trademark product. In such a situation, the distributor's efforts may have enhanced the value of its own intangibles, namely its distribution rights. In such cases, the distributor's share of benefit should be determined based on what an independent distributor would receive in comparable circumstances. In some cases, a distributor may perform functions, use assets, or assume risks that exceed those an independent distributor with similar rights might incur or perform for the benefit of its own distribution activities, and that create value beyond that created by other similarly situated marketers or distributors. An independent distributor in such a case would typically require additional remuneration from the owner of the trademark or other intangibles. such remuneration could take the form of higher distribution profits, resulting from a decrease in the purchase price of the product. Okay, so as you can see in this example, this is a very, very specific example of how the payment for intangible can be received by the party who are involved in the transactions. So the remuneration could take the form of higher distribution profits, meaning if you are a distributor, then you can add a higher markup compared to those who are not participant to the development of the intangibles, resulting from a decrease in the purchase price of the product, a reduction in royalty rate, or a share of the profits associated with the enhanced value of the trademark or other marketing intangibles in order to compensate the distributor for its functions, assets, risks, and anticipated value creation. Examples 8 to 13 in the annex to Chapter 6 illustrate in greater detail the application of this Section B in the context of marketing and distribution arrangements. Research development and process improvement arrangements. The principles set out in the foregoing paragraphs also apply in situations involving the performance of research and development functions by a member of an M&E group under a contractual arrangement with an associated enterprises that is the legal owner of any resulting intangibles. Appropriate compensation for research services will depend on all the facts and circumstances, such as whether the research team possesses unique skills and experience relevant to the research, assumes risk where blue sky research is undertaken, uses its own intangibles, or is controlled and managed by another party. Compensation based on a reimbursement of cost plus a modest markup will not reflect the anticipated value of or the arm's length price for the contributions of the research team in all cases. So the principles set out in this section similarly apply in situations where a member of an M&E group provides manufacturing services that may lead to process or product improvements on behalf of an associated enterprise that will assume legal ownership of such process or product improvements. Example 14 to 17 in the annex to Chapter 6 illustrate in greater detail the application of this Section B in the context of research and development arrangements. So there are so many cases, examples regarding this intangible in the annex. So payments for use of the company name. Okay. Excuse me. Payments for use of the company name. Questions often arise regarding the arm's length compensation for the use of group names, trade names, and similar intangibles. The most popular use of of group names here in the Philippines is that of SM, no? The SM group of companies. Why? Because even if they are using the SM name, the corporations or the entities are different because they are registered in different corporations, although still the owners are the same. For the use of group names, trade names, and similar intangibles. Resolution of such questions should be based on the principles of this Section B and on the commercial and legal factors involved. As a general rule, no payment should be recognized for transfer pricing purposes for simple recognition of group membership or the use of group name merely to reflect the fact of group membership. See paragraph 7.12. Where one member of the group is the owner of a trademark or other intangible for the group name, and where use of the name provides a financial benefit to members of the group other than the member legally owning such intangible. It is reasonable to conclude that a payment for use would have been made in arm's length transactions. Similarly, such payments may be appropriate where a group member owns goodwill in respect of the business represented by an unregistered trademark. Use of the trademark by another party would constitute misrepresentation, and the use of the trademark provides a clear financial benefit to a group member other than that owning the goodwill and unregistered trademark. Determining the amount of payment with respect to a group name, it is important to consider the amount of the financial benefit to the user of the name attributable to use of that name, the cost and benefits associated with other alternatives, and the relative contributions to the value of the name made by the legal owner and the entity using the name in the form of functions performed, assets used, and risk assumed. Careful consideration should be given to the function performed, assets used, and risk assumed by the user of the name in creating or enhancing the value of the name in its jurisdiction. Factors that would be important in a licensee in a license of the name to an independent enterprise under comparable circumstances applying the principles of chapters 1 to 3 should be taken into account. So what's that? Chapters 1 to 3 that deals with the arm's length principle. Where an existing successful business is acquired by another successful business and the acquired business begins to use a name, trademark, or other branding indicative of the acquiring business, there should be no automatic assumption that a payment should be made in respect of such use. Why? Because the business that uses the new name is already a successful business. So meaning it can thrive even without this new name. If there is a reasonable expectation of financial benefit to the acquired company from using the acquiring company's branding, then the amount of any payment should be informed by the level of that anticipated benefit. May also be the case that acquiring business will leverage the existing position of the acquired business to expand the business of the acquirer in the territory of operation of the acquired business by causing the acquired business to use the acquirer's branding. In that case, consideration should be given to whether the acquirer should make a payment to or otherwise compensate the acquired business for the functions performed, risk assumed, and assets used, including its market position, in connection with expanded use of the acquirer's name. Transactions involving the use or transfer of intangibles. In addition to identifying with specificity the intangibles involved in a particular transfer pricing issue and identifying the owner of such intangibles, it is necessary to identify and properly characterize at the beginning of any transfer pricing analysis involving intangibles the specific control transactions involving intangibles. So what are the control transactions that there you can see that the intangibles are used? The principles of chapter 1 apply in identifying and accurately delineating transactions involving the use or transfer of intangibles. In addition to the guidance on identifying the actual transaction, Section D.1 of Chapter 1 and on business restructuring, Chapter 9, especially Part 1. Section C of this chapter outlines some typical scenarios that may be useful in ascertaining whether intangibles or rights in intangibles are involved in a transaction. See example 19. The characterization of a transaction for transfer pricing purposes has no relevance for determinations under Article 12 of the OECD Model Tax Convention. See paragraphs 8 to 19 of the commentary to Article 12 of the OECD Model Tax Convention. There are two general types of transactions where the identification and examination of intangibles will be relevant for transfer pricing purposes. These are transactions involving transfers of intangibles or rights in intangibles and transactions involving the use of intangibles in connection with the sale of goods or the provision of services. Transactions involving transfers of intangibles or rights in intangibles. Transfers of intangibles or rights in intangibles. Rights in intangibles themselves may be transferred in controlled transactions. Such transactions may involve a transfer of all rights in the intangibles in questions, sale of the intangible, or a perpetual exclusive license of the intangible or only limited rights. A license or similar transfer or limited rights to use an intangible which may be subject to geographical restrictions, limited duration, or restrictions with respect to the right to use, exploit, reproduce, further transfer, or further develop. The principles of chapters 1-3 apply to transactions involving the transfer of intangibles or rights in intangibles. Supplemental guidance regarding the determination of arm's length conditions for such transactions is also contained in sections D.1, D.2, and D.3 of this chapter. In transactions involving the transfer of intangibles or rights in intangibles, it is essential to identify with specificity the nature of the intangibles and rights in intangibles that are transferred between associated enterprises. Where limitations are imposed on the rights transferred, it is also essential to identify the nature of such limitations and the full extent of the rights transferred. It should be noted in this regard that the labels applied to transactions do not control the transfer pricing analysis. For example, in the case of a transfer of the exclusive right to exploit a patent in country X, the taxpayer's decision to characterize the transaction either as a sale of all of the country X patent rights or as a perpetual exclusive license of a portion of the worldwide patent rights does not affect the determination of the arm's length price if, in either case, the transaction being priced is a transfer of exclusive rights to exploit the patent in country X over its remaining useful life. Thus, the functional analysis should identify the nature of the transferred rights in intangibles with specificity. Restrictions imposed in license and similar agreements on the use of an intangible in the further development of new intangibles or new products using the intangibles are often of significant importance in a transfer pricing analysis. It is therefore important in identifying the nature of a transfer of rights in intangibles to consider whether the transferee receives the right to use the transferred intangible for the purpose of further research and development. In transactions between independent enterprises, arrangements are observed where the transferor or licensor retains the full right to any enhancements of the license intangible that may be developed during the term of the license. Transactions between independent enterprises are also observed where the transferee licensee retains the right to any enhancement it may develop, either for the term of its license or in perpetuity. The nature of any limitations on further development of transferred intangibles or on the ability of the transferee and the transferor to derive an economic benefit from such enhancement can affect the value of the rights transferred and the comparability of two transactions involving otherwise identical or closely comparable intangibles. Such limitation must be evaluated in light of both the written terms of agreements and the actual conduct of the affected parties. The provisions of section D.1.1 of chapter 1 apply in identifying the specific nature of a transaction involving a transfer of intangibles or rights in intangibles in identifying the nature of any intangibles transferred. And in identifying any limitations imposed by the term of the transfer on the use of those intangibles. So for example, a written specification that a license is non-exclusive or of limited duration need not be respected by the tax administration if such specification is not consistent with the conduct of the parties. Example 18 in the Annex to Chapter 6 illustrates the provisions of this paragraph. Transfers of combinations of intangibles. Intangibles, including limited rights in intangibles, may be transferred individually or in combination with other intangibles. In considering transactions involving transfers of combinations of intangibles, two related issues often arise. The first of these involves the nature and economic consequences of interactions between different intangibles. It may be the case that some intangibles are more valuable in combination with other intangibles than would be the case if the intangibles were considered separately. It is therefore important to identify the nature of the legal and economic interactions between intangibles that are transferred in combination. For example, a pharmaceutical product will often have associated with it three or more types of intangibles. The active pharmaceutical ingredient may be protected by one or more patents. The product will also have been through a testing process, and a government regulatory authority may have issued an approval to market the product in a given geographic market and for specific approved indications based on that testing. The product may be marketed under a particular trademark. In combination, these intangibles may be extremely valuable. In isolation, one or more of them may have much less value. For example, the trademark without the patent and the regulatory marketing approval may have limited value since the product could not be sold without the marketing approval, and generic competitors could not be excluded from the market without the patent. Similarly, the value of the patent may be much greater once regulatory marketing approval has been obtained than would be the case in the absence of the marketing approval. The interactions between each of these classes of intangibles, as well as which parties perform functions, bore the risk and incur the cost associated with securing the intangibles, are therefore very important in performing a transfer pricing analysis with regard to a transfer of the intangibles. It is important to consider the relative contribution to value creation, where different associated enterprises hold rights in the intangibles used. A second unrelated issue involves the importance of ensuring that all intangibles transferred in a particular transaction have been identified. It may be the case, for example, that intangibles are so intertwined that it is not possible as a substantive matter to transfer one without transferring the other. Indeed, it will often be the case that a transfer of one intangible will necessarily imply the transfer of other intangibles. In such cases, it is important to identify all of the intangibles made available to the transferee as a consequence of an intangible transfer, applying the principles of section D.1 of chapter 1. For example, the transfer of rights to use a trademark under a license agreement will usually also imply the licensing of the reputational value, sometimes referred to as goodwill, associated with that trademark, where it is the licensor was built up such goodwill. Any license fee required should consider both the trademark and the associated reputational value. Example 20 in the annex to chapter 6 illustrates the principles of this paragraph. It is important to identify situations where taxpayers or tax administrations may seek to artificially separate intangibles that, as a matter of substance, independent parties would not separate in comparable circumstances. For example, attempts to artificially separate trademarks or trade names from the goodwill or reputational value that is factually associated with the trademark or trade name should be identified and critically analyzed. Example 21 in the annex to chapter 6 illustrates the principles of this paragraph. No? So after this chapter 6, we will go to annex. No? So there are so many examples. It should be recognized that the process of identifying all of the intangibles transferred in a particular transaction is an exercise of identifying by reference to written agreements and the actual conduct of the parties, the actual transactions that have been undertaken, applying the principles of section D.1 of chapter 1. So even if the transfer pricing issue of intangibles are complicated, but because of the annexes to this chapter 6 on intangibles, then we will have a very much enlightening examples on intangibles, and we will not be confused, no? Because of the different examples with different scenarios, so we can more or less have a clearer example on what to do or when confronted by any issues in intangibles. Transfers of intangibles or rights in intangibles in combination with other business transactions. In some situations, intangibles or rights in intangibles may be transferred in combination with tangible business assets or in combination with services. It is important in such a situation to determine whether intangibles have in fact been transferred in connection with the transaction. It is also important that all of the intangibles transferred in connection with a particular transaction be identified and taken into account in the transfer pricing analysis. Examples 23 to 25 in the annex to Chapter 6 illustrate the principles of this paragraph. In some situations, it may be both possible and appropriate to separate transactions in tangible goods or services from transfers of intangibles or rights in intangibles for purposes of conducting a transfer pricing analysis. In these situations, the price of a package contract should be disaggregated in order to confirm that each element of the transaction is consistent with the arm's length principle. In other situations, transactions may be so closely related that it will be difficult to segregate tangible goods or service transactions from transfers of intangibles or rights in intangibles. Reliability of available comparables will be an important factor in considering whether transactions should be combined or segregated. In particular, it is important to consider whether available comparables permit accurate evaluation of interactions between transactions. One situation where transactions involving transfers of intangibles or rights in intangibles may be combined with other transactions involves a business franchise arrangement. Under such an arrangement, one members of an M&A group may agree to provide a combination of services and intangibles to an associated enterprise in exchange for a single fee. If the services and intangibles made available under such an arrangement are sufficiently unique that reliable comparables cannot be identified for the entire service intangible package, it may be necessary to segregate the various parts of the package of services and intangibles for separate transfer pricing consideration. It should be kept in mind, however, that the interactions between various intangibles and services may enhance the value of both. In other situations, the provision of a service and the transfer of one or more intangibles may be so closely intertwined that it is difficult to separate the transaction for purposes of a transfer pricing analysis. For example, some transfer of rights in software may be combined with an undertaking taking by the transfer to provide ongoing software maintenance services, which may include periodic updates of the software. In situations where services and transfers of intangibles are intertwined, determining arm's length prices on an aggregate basis may be necessary. It should be emphasized that delineating the transaction as the provision of products or services or the transfer of intangibles or a combination of both does not necessarily dictate the use of a particular transfer pricing method. For example, a cost-plus approach will not be appropriate for all service transactions, and not all intangible transactions require complex valuation or the application of profit split methods. The fact of each specific situation and the results of the required functional analysis will guide the manner in which transactions are combined, delineated, and analyzed for transfer pricing purposes, as well as the selection of the most appropriate transfer pricing method in a particular case. The ultimate objective is to identify the prices and other relevant conditions that would be established between independent enterprises in comparable transactions. Moreover, it should also be emphasized that determinations as to whether transactions should be aggregated or segregated for analysis usually involve the delineation of the actual transaction undertaken by reference to written agreements and the actual conduct of the parties. Determinations regarding the actual transactions undertaken constitute one necessary element in determining the most appropriate transfer pricing method in the particular case. Transactions involving the use of intangibles in connection with sales of goods or performance of services. Intangibles may be used in connection with controlled transactions in situations where there is no transfer of the intangible or of rights in the intangible. For example, intangibles may be used by one or both parties to a controlled transaction in connection with the manufacture of goods sold to an associated enterprise, in connection with the marketing of goods purchased from an associated enterprise, or in connection with the performance of services on behalf of an associated enterprise. The nature of such a transaction should be clearly specified, and any relevant intangibles used by either of the parties in connection with such a controlled transaction should be identified and taken into account in the comparability analysis, in the selection and application of the most appropriate transfer pricing method for that transaction, and in the choice of the tested party. Supplemental guidance regarding the determination of arm's length conditions for transactions involving the use of intangibles in connection with the sale of goods or the provision of services is contained in sections D.1 and D.4 of this chapter. The need to consider the use of intangibles by a party to a controlled transaction involving a sale of goods can be illustrated as follows. Assume that a car manufacturer uses valuable proprietary patents to manufacture the cars that it then sells to associated distributors. Assume that the patents significantly contribute to the value of the cars. The patents and the value they contribute should be identified and taken into account in the comparability analysis of the transaction consisting in the sales of cars by the car manufacturer to its associated distributors in selecting the most appropriate transfer pricing method for the transactions and in selecting the tested party. The associated distributors purchasing the cars do not, however, acquire any right in the manufacturer's patents. In such a case, the patents are used in the manufacturing and may affect the value of the cars, but the patent themselves are not transferred. So this is very clear, especially in the use of patent. So the mere exploitation of the patent does not in itself transfer the ownership of the patent. Okay. As another example of the use of intangibles in connection with a controlled transaction, assume that an exploration company has acquired or developed valuable geological data and analysis and sophisticated exploratory software and know-how. Assume further that it uses those intangibles in providing exploration services to an associated enterprise. Those intangibles should be identified and taken into account in the comparability analysis of the service transactions between the exploration company and the associated enterprise in selecting the most appropriate transfer pricing method for the transaction and in selecting the tested party. Assuming that the associated enterprise of the exploration company does not, excuse me, acquire any rights in the exploration company's intangibles. The intangibles are used in the performance of the services and may affect the value of services but are not transferred. No? So very clear. Supplemental guidance for determining arm's length condition in cases involving intangibles. After identifying the relevant transactions involving intangibles, specifically identifying the intangibles involved in those transactions, identifying which entity or entities legally own the intangibles, as well as those that contribute to the value of the intangibles, it should be possible to identify arms and conditions for the relevant transactions. The principles set out in chapters 1 to 3 of these guidelines should be applied in determining arm's length conditions for transactions involving intangibles. In particular, the recommended 9-step process set out in paragraph 3.4 can be helpful, that is about comparability analysis, in identifying arm's length conditions for transactions involving intangibles. As an essential part of applying the principles of Chapter 3 to conduct a comparability analysis under the process described in paragraph 3.4, the principles contained in sections A, B, and C of this Chapter 6 should be considered. However, the principles of Chapter 1 to 3 can sometimes be difficult to apply to control transactions involving intangibles. Intangibles may have special characteristics that complicate the search for comparables and in some cases make pricing difficult to determine at the time of the transaction. Further, for wholly legitimate business reasons, due to the relationship between them, associated enterprises might sometimes structure a transaction involving intangibles in a manner that independent enterprises would not contemplate. See paragraph 1.11. The use of transfer of intangibles may raise challenging issues regarding comparability, selection of transfer pricing methods, and determination of arms and conditions for transactions. The Section D provides supplemental guidance for use in applying the principle of Chapters 1 to 3 to determine arm's length conditions for controlled transactions involving intangibles. Section D.1 provides general supplemental guidance related to all transactions involving intangibles. Section D.2 provides supplemental guidance specifically related to transactions involving the transfer of intangibles or rights in intangibles. Section D.3 provides supplemental guidance regarding transfers of intangibles or rights in intangibles whose value is highly uncertain at the time of the transfer. Section D.4 provides an approach to pricing hard-to-value intangibles. Section D.5 provides supplemental guidance applicable to transactions involving the use of intangibles in connection with the sale of goods or the provision of services in situations where there is no transfer of rights in the intangibles. General principles applicable in transactions involving intangibles. Section D of Chapter 1 and Chapter 3 contain principles to be considered and a recommended process to be followed in conducting a comparability analysis. The principles described in those sections of the guidelines apply to all controlled transactions involving intangibles. In applying the principles of the guidelines related to the content and process of a comparability analysis to a transaction involving intangibles, a transfer pricing analysis must consider the options realistically available to each of the parties to the transaction. Considering the options realistically available to the parties, the perspectives of each of the parties to the transaction must be considered. A comparability analysis focusing only on one side of a transaction generally does not provide a sufficient basis for evaluating a transaction involving intangibles, including in those situations for which a one-sided transfer pricing method is ultimately determined. While it is important to consider the perspective of both parties to the transaction in conducting a comparability analysis, the specific business circumstances of one of the parties should not be used to dictate an outcome contrary to the realistically available options of the other party. For example, a transferor would not be expected to accept a price for the transfer of either all or part of its rights in an intangible that is less advantageous to the transferor than each other realistically available options, including making no transfer at all, merely because a particular associated enterprise transferee lacks the resources to effectively exploit the transferred rights in the intangible. Similarly, a transferee should not be expected to accept a price for a transfer of rights in one or more intangibles that would make it impossible for the transferee to anticipate earning a profit using the acquired rights in the intangible in its business. Such an outcome would be less favorable to the transferee than its realistically available option of not engaging in the transfer at all. So that's the difficulties in intangibles, because as we see, intangibles has no physical attributes. No? Um, so it is difficult to look for comparables, especially if that intangibles is unique. It will often be the case that a price for a transaction involving intangibles can be identified that is consistent with the realistically available options of each of the parties. The existence of such prices is consistent with the assumption that M&E groups seek to optimize resource allocations. If situations arise in which the minimum price acceptable to the transferor based on its realistically available options exceeds the maximum price acceptable to the transferee based on its realistically available options, it may be necessary to consider whether the actual transaction should be disregarded under the criterion for non-recognition set out in Section D.2 of Chapter 1, or whether the conditions of the transaction should otherwise be adjusted. Similarly, if situations arise in which there are assertions that either the current use of an intangible or a proposed realistically available option, an alternative use of the intangible does not optimize resource allocations, it may be necessary to consider whether such assertions are consistent with the true facts and circumstances of the case. This discussion highlights the importance of taking all relevant facts and circumstances into account in accurately delineating the actual transaction involving intangibles. D.2 Supplemental guidance regarding transfers of intangibles or rights in intangibles. So this is already a supplemental guidance. This section provides supplemental guidance regarding specific issues in connection with the transfer between associated enterprises of intangibles or rights in intangibles. Such transactions may include sales of intangibles as well as transactions that are economically equivalent to sales. Economically equivalent to sales. So in substance, that is equivalent to sales. Just like in the value-added tax, there is a sales, considered sales, but they are just deemed sale transactions. They are not actually sales, but they are considered sales for VAT purposes. So just like in intangibles, there is also what we see as deemed intangibles, no? Deemed transfer. Economically equivalent to sales. No? So the form may be different, but the substance is similar to sales. Such transactions could also include a license of rights in one or more intangibles or a similar transaction. This section is not intended to provide comprehensive guidance with regard to the transfer pricing treatment of such intangibles transfers. Rather, it supplements the otherwise applicable provisions of chapters 1 to 3 and the guidance in section A, B, C, and D.1 of this chapter in the context of transfers of intangibles or rights in intangibles by providing guidance with regard to certain specific topics commonly arising in connection with such transfers. Comparability of intangibles or rights in intangibles. In applying the provisions of chapters 1 to 3 to transactions involving the transfer of intangibles or rights in intangibles, it should be borne in mind that intangibles often had unique characteristics and as a result have the potential for generating returns and creating future benefits that could differ widely. In conducting a comparability analysis with regard to a transfer of intangibles, it is therefore essential to consider the unique features of the intangibles. This is particularly important where the CAP method is considered to be the most appropriate transfer pricing method, but also has importance in applying other methods that rely on comparables. In the case of a transfer of an intangible or rights in an intangible that provides the enterprise with a unique competitive advantage in the market, purportedly comparable intangibles or transactions should be carefully scrutinized. It is critical to assess whether potential comparables in fact exhibit similar profit potential. Set out below is a description of some of the specific features of intangibles that may prove important in a comparability analysis involving transfers of intangibles or rights in intangibles. The following list is not exhaustive, and in a specific case, consideration of additional or different factors may be an essential part of a comparability analysis. Exclusivity. Whether the rights in intangibles relevant to a particular transaction involving the transfer of intangibles or rights in intangibles are exclusive or non-exclusive can be an important comparability consideration. Some intangibles allow the legal owner of the intangible to exclude others from using the intangible. A patent, for example, grants an exclusive right to use the invention covered by the patent for a period of years. If the party controlling intangible rights can exclude other enterprises from the market or exclude them from using intangibles that provide a market advantage, that party may enjoy a high degree of market power or market influence. A party with non-exclusive rights to intangibles will not be able to exclude all competitors and will generally not have the same degree of market power or influence. Accordingly, the exclusive or non-exclusive nature of intangibles or rights in intangibles should be considered in connection with the comparability analysis. Extent and duration of legal protection. This is still a supplemental guidelines. The extent and duration of legal protection of the intangibles relevant to a particular transfer can be an important comparability consideration. Legal protections associated with the sum intangibles can prevent competitors from entering a particular market. For other intangibles such as know-how or trade secrets, available legal protections may have a different nature and not be as strong or last as long. For intangibles with limited useful lives, the duration of legal protections can be important since the duration of the intangible rights will affect the expectations of the parties to a transaction with regard to the future benefits from the exploitation of the intangible. For example, two otherwise comparable patents will not have equivalent value if one expires at the end of 1 year while the other expires only after 10 years. So they have a different life, no? Different expiration. Geographic scope. The geographic scope of the intangibles or rights in intangibles will be an important comparability consideration. A global grant of rights to intangibles may be more valuable than a grant limited to one or a few countries, depending on the nature of the product, the nature of the intangible, and the nature of the markets in question. Useful life. Many intangibles have a limited useful life. The useful life of a particular intangible can be affected by the nature and duration of the legal protections afforded to the intangible as noted above. The useful life of some intangibles can also be affected by the rate of technological change in the industry and by the development of new and potentially improved products. It may also be the case that the useful life of particular intangibles can be extended. In conducting a comparability analysis, it will therefore be important to consider the expected useful life of the intangibles in question. In general, intangibles expected to provide market advantages for a longer period of time will be more valuable than similar intangibles providing such advantages for a shorter period of time, other things being equal. In evaluating the useful life of intangibles, it is also important to consider the use being made of the intangible. The useful life of an intangible that forms a base for ongoing research and development may extend beyond the commercial life of the current generation product line based on that intangible. The most useful intangible are that have a very long life. No? Stages of development. In conducting a comparability analysis, it may be important to consider the stage of development of particular intangibles. It is often the case that an intangible is transferred in a control transaction at a point in time before it has been fully demonstrated that the intangible will support commercially viable products. A common example arises in the pharmaceutical industry, where chemical compounds may be patented and the patents or rights to use the patents transferred in controlled transactions well in advance of the time when further research, development, and testing demonstrates that the compound constitutes a safe and effective treatment for a particular medical condition. As a general rule, intangibles relating to products with established commercial viability will be more valuable than otherwise comparable intangibles relating to products or whose commercial viability is yet to be established. In conducting a comparability analysis involving partially developed intangibles, it is important to evaluate the likelihood that further development will lead to commercially significant future benefits. In certain circumstances, industry data regarding the risk associated with further development can be helpful to such evaluations. However, the specific circumstances of any individual situation should always be considered. Rights to enhancements, revisions, and updates. Often, an important consideration in a comparability analysis involving intangibles relates to the rights of the parties with regard to future enhancements, revisions, and updates of the intangibles. In some industries, products protected by intangibles can become obsolete or uncompetitive in a relatively short period of time in the absence of continuing development and enhancement of the intangibles. As a result, having access to updates and enhancement can be the difference between deriving a short-term advantage from the intangibles and deriving a longer-term advantage. It is therefore necessary to consider for comparability purposes whether or not a particular grant of rights in intangibles includes access to enhancement, revision, and updates of the intangibles. A very similar question, often important in a comparability analysis, involves whether the transferee of intangibles obtain the right to use the intangibles in connection with research directed to developing new and enhanced intangibles. For example, the right to use an existing software platform as a basis for developing new software products can shorten development times and can make the difference between being the first to market with a new product or application or being forced to enter a market already occupied by established competitive products. A comparability analysis with regard to intangibles should therefore consider the rights of the parties regarding the use of the intangibles in developing new and enhanced version of the products. So the discussions on intangibles are very, very interesting because even if this uh, discussion on intangibles is somewhat difficult, but as you know, you have already the idea on the principle of how these intangibles are valued, how they are recognized, and what are the transactions that will involve intangible, then it will not be difficult for one who is doing a transfer pricing analysis to consider transfer pricing issues, especially if the application of the arm's length principle has to be applied. And what is that application of the arm's length principle? To put the related party the taxpayers in parity with that of the independent party taxpayers. Also, it will always redound to the uh, application of the arm's length principle, which is embodied in Article 9 of the OECD Model Tax Convention. And particularly when it comes into the Philippines, it is embodied in Section 50 of the National Internal Revenue Code. So along the way, the documentation requirements that would be required in intangibles is more complicated as compared to that of the other issues in intangibles, just like intragroup services, just like business restructuring. So just continue with our discussions. We will just continue with our searching for a complete knowledge in intangibles as what is embodied here in this supplemental guidelines and also guidelines as set by the OECD. We will be more clearer. It will be more clearer for us if we will go to the discussions on the annexes because there are so many examples that, as I told you, the examples in annexes to the to the intangibles contained in Chapter 6 contains many scenarios that the transfer pricing issues will evolve. No? So we will have a guide. So it's a very fruitful discussion tonight. So please bear with us, no, because the knowledge in transfer pricing cannot just be easily acquired. No? We have to exert some effort in order to obtain knowledge in transfer pricing. So, ilan na yung ating ano, Hari?
Yung viewers, ma'am, na 7 viewers pa.
Okay, so with that, I would like to say thank you sa ating mga subscribers po. We have 249 subscribers already. So please bear with us as we go along. And after we will finish discussing this OECD transfer pricing guidelines, then we will go to jurisprudence and to some technical issues still in transfer pricing. So with that, I would like to say thank you and have a good night.